And welcome once again, Employment Law Show. John Scholes along with Lior Samfiru, still doing the physical distancing thing for the next little while anyway, but same show as always, coming at you, lots of information. Reaching out is simple. It's going to be help@employmentlawyer.ca, 1-855-821-5900. And remember, anytime you want to use it, absolutely free and anonymous, pocketemploymentlawyer.ca. Coming up on the show today, what employers shouldn't do, what they shouldn't do. So make sure you stick around for that. And some phone calls from our live radio show that you can catch anytime across the country. We'll give you details on how to do that as well. But we always start, Lior, with the week that was. How was it?
Still very, very busy. I think that as things progress, I see more and more people, unfortunately, losing their jobs. So whereas in the previous months when COVID started, I was dealing mostly with advising people about their temporary layoffs. Now a lot of these layoffs are becoming actual terminations. People are finding out that they're not going back to work. So I've been helping a lot of people to understand what their rights are if they're out of a job, what they're owed, how to get what they're owed, and how to navigate that situation. And, you know, if you're in that situation right now where either you know you don't have a job or you're worried about losing your job and what that's going to mean to you, your family, your livelihood, we're going to talk about that, your rights, your employer's obligations. We're going to try to give you as much information as possible so that you understand what you can do if you're in the unfortunate situation now you've lost your job. And we're going to cover a lot of topics on this show that I think are going to be important and relevant. We're going to send you to some resources as well. But of course, if you want to talk to me privately, if you want to just have a conversation about your matter, not a problem. We'll give you my contact information throughout the show. You can call, you can email. Let's have that discussion. Let's help you solve the problem. You know, we may be in quarantine or in self-isolation, but employment law isn't. Employment law is still out there doing what it's supposed to be doing. Now, let me start off, Johnny, with a situation that came across my desk very recently. And I've said before on the show many times that short service employees that have worked for, let's say, a couple of years or less, are treated disproportionately better when it comes to severance than long-term employees. So you may have an employee that's only worked for a few months that could be owed a few months' pay. Well, here's a situation where that's happened. And in fact, this person was owed even more severance than one would expect. This person started working for a company in January, right after the holidays. He was recruited from another company that he was working at previously for about 7 or 8 years. Yeah, a headhunter came at him and recruited him away. He started in January, then COVID hit. In April, the company says, unfortunately, because of COVID, we got to let you go. We don't have a job for you anymore. So they say, you know, we're going to be nice to you. We're going to give you 2 weeks' pay, and off you go. He called me and he wanted to know, is that right? Is that all I'm owed here? You know, I left a job of 8 years. Now I'm out of a job. So here's the thing, John. Because he was recruited away from a job, he wasn't out there shopping his resume. He wasn't asking for this job. He was recruited away. Now that he's let go, he's owed severance that accounts for his time with the previous company. So now, even though he only worked 3 months, the law says that severance should be paid as if he's worked there for 8 years. To account for the previous time with the company. So now he's going to be owed 8-9 months pay, even though he only worked for 3 months. Now, your situation may be different. You may not have been recruited, but even if you're just a regular short service employee that lost your job now, you're still going to be owed severance that's calculated in the months, not in the days or the weeks. And of course, if you have been recruited from another job, that means even more severance. So you really got to get that advice if you lost your job.
Employmentlawyer.ca, that is the website we use. You can go there to find a radio show somewhere on a station near you. We've been doing it for about 8 years, give or take now. We take a lot of phone calls on the show when we talk about them on this show. First call of the day, Lior, is coming up right now.
My father, he's worked for the same company for over 30 years. He is going to be 72 in the fall. Now, if I've got my labor law right, they don't have to keep you on after 70. They can let you go with no reason whatsoever. Is that correct?
A lot of wrong. A lot of wrong.
I remember this call, John. I think you do as well. And, you know, we started this show and our radio show all these years ago because of misconceptions, because of the idea that people believe certain things about their rights, about employment law. They're not just wrong. They're just false. Well, this caller that we had on our radio show believes something that's a perfect example of things that are just wrong. She believes that after 70, if they let you go, they don't have to pay you anything. Wow. Nonsense. Not even close. Age doesn't matter. You could be, whether you're 37 or 77, you're owed severance. Not only that, John, the older you are, the more severance you are owed. So at 70, he's going to be owed more severance than when he was 50 or 40. So don't believe anything that suggests you don't get severance. You can't be made to retire. You have a right to work as long as you want to, as long as you can. You can't be made to retire. You can't be sent out, without a job. And in fact, if you were to let go because of your age, that is a human rights violation. So John, this guy's worked there for 30 years. He's 70 years old. I know, and you know exactly how many months pay he's owed. But for those at home that may not know or understand, by the way, it's 24 months. But how we get there, let's go to pocketemploymentlawyer.ca right now. Let's plug his information in and see what we get. So we know this person in his 70s. Let's say he's in a sales role. He was let go, wasn't paid anything because, hey, 70 years old, you don't get severance. Except you see on the screen there, he's owed 24 months paid, 2 years paid. And potentially there could be human rights damages if he was let go because of his age. So what we're looking at is from pocketemploymentlawyer.ca. You can go there yourself. There's a severance calculator tool there to allow you to find out how much you're owed. And John, I hate hearing these misconceptions. And hopefully with this show, we can reach as many people as possible and tell them the truth.
Again, pocketemploymentlawyer.ca is the place you want to go anytime. There's all kinds of information, and wrapped up into that, as Lior just mentioned, and use the severance pay calculator, so go there anytime. It's anonymous. If you want to just click off and walk away, you can do so, or reach out. There's a contact button on the top right of the Pocket Employment Lawyer. Termination questions, that's another place you can go. There's all kinds of resources from terminationquestions.com. Ask your questions. This one comes from Daniel. Lior says, my brother's work just gave him an option regarding his job. He can return from his temporary layoff at half pay, or he can choose to resign and look for new employment. Which is the best option? I'm saying option number 3 is probably the best option.
That's right. This question really assumes within it that those are the only option.
Right.
And I get that often when people are asking me questions where the real question they should be asking is something else. The real question they should be asking, are these really his only options, as opposed to which one is better? There's the third option. The third option is none of the above, only because an employer is not allowed to reduce pay. Usually when it comes to more than 10%, your employer is not allowed to make such a pay reduction. In this case, they're saying 50%. Well, if he refuses to accept the 50% pay cut, and frankly, I think most people would, that is a constructive dismissal. Your employer does not have a right to do that, meaning you haven't resigned, meaning your employer essentially terminated your employment, and now they have to pay you severance. So the employer says either come back to work or that's a resignation. No, it's either come back to work or you get severance. Those are the options. No one can tell you to resign. It's important to remember that. You're the only one that can decide that. And if you're now faced with a situation where your employer says, I got to reduce your pay. Well, one of the options you have, the employee, is to either accept that or to treat that as a termination, as a constructive dismissal, and get your full severance.
Could he come back and say, you know what, I don't like the reduction in pay. I might be able to make it work just because I love the company so much. Can I just take it for a bit of a spin on a trial thing? And if it doesn't work, I'm not doing it.
Two things he could do potentially. Number one is that he can actually say, employer, well, I want to help you out, so I'll agree to this for the next 2 weeks, 2 months, some limited time. But after that, I expect to be back to my normal pay. That's one thing. I actually like that idea. The other thing that the employee can do, as you've just said, say, well, employer, I don't know if I can make ends meet. Let me try this for a little while and see what happens. You can try that for a few weeks, as long as you tell your employer that's what you're doing. And after a few weeks, if it's not working, you need more money to pay your bills, you can still treat that as a constructive dismissal. But what you don't want to do is just go back to work, say nothing, and just accept a pay cut, because then you may never get your pay back, and you can also then be giving the company the right to reduce your pay again in the future.
And if you do want to try it, make sure you get that in writing, right? Always.
If it's not in writing, it doesn't exist. Now, anything verbal, not a good idea. Email works so well. We have email. It takes seconds. Use it.
What employers shouldn't do, that is coming up after we take a short break, so stick around for it. 1-855-821-5900 and employmentlawyer.ca. Lots more of the Employment Law Show is on the way. Stick around.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. Severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back, Employment Law Show. John Scholes, Lior Samfiru. By the way, you want to reach out anytime, send an email, help@employmentlawyer.ca. We'll put the contact information on the screen during the entire show, so you're covered in that regard. I want to get to this, Lior, and that is what employers should do. You whittled this down to 6 points. It could have been 606, but time is of the essence here, so you got it down to 6. These are really important, right?
It is important. It's mistakes that employers often make that get them into legal trouble, and it's things that employers and employees need to know about. So if you're an employee and your employer is doing one of those things that we're going to be talking about, now you know it's wrong. And now we'll also tell you what to do about it. For both employers and employees, this is vital. Employers often complain that the law is too harsh on them. Well, guess what? We're going to talk to you about some things to do and not to do so that you stay out of legal trouble.
All right, first one, let's get it rolling right away. What employers shouldn't do is this. Don't fire an employee for cause if you actually don't have just cause.
Right. And this seems simple, but John, employers get this wrong all the time. A termination for cause, meaning it's a situation where the employer lets the employee go because they did something terrible, something awful. And if in fact the employee did do that, that employer can let the employee go without compensation, without severance. The problem here, and that's what we're talking about, is that employers pull the trigger on a termination for cause well before they should, meaning they don't actually have cause. They either haven't given the employee warnings, they haven't built a case against them, or simply whatever the employee did may have been wrong, but not bad enough to be cause. The fact that the employee did something wrong does not mean that that is cause for dismissal. Just like if you're guilty of a crime, doesn't mean that you automatically get life in prison. It's only for the worst offenders. So I speak with people all the time that have been let go for cause. In fact, they've been wrongfully dismissed. So employers, to terminate someone for cause, you need to have past warnings, past disciplinary measures. You have to show that you've done everything you can to fix the situation, but you failed. And that all has to be in writing. If you simply say, aha, employee, you did something wrong, I'm going to let you go for cause, almost always that's a wrongful dismissal, and you're going to have to face legal action in a claim because of it.
Talking about what employers shouldn't do, next one is this. Don't change your employer's pay, hours, duties, unless you absolutely have to.
Yeah, and even then, John, if you change your employer's and employees' terms of employment, you're often going to face a constructive dismissal claim. Now, listen, if it's life or death, you have to do what you have to do. But generally speaking, if you change an employee's pay, hours, reporting relationship, or demote them, that is a significant change, and you're not allowed to do that. If you do that, you give the right to the employee to treat that as a constructive dismissal. And for you as an employee, if your employer does that to you, you can always accept that change, or you can decide to treat that as a termination of your employment. You can't physically stop your employer from changing terms of employment, but you can certainly reject it and treat that as a termination of employment. So employers, keep that in mind. You can always have an employment agreement that gives you the power and the ability to make changes. But if you don't have an employment agreement, most of these changes are illegal, are not appropriate, and you may then face legal action. So important for both employees and employers to understand that.
Going through a short list of things that employers shouldn't do. This one's a big one as well. Don't fire an employee if they're not ready to return from a disability leave, or if their doctor says they need to be on one.
Right. This is key, and this almost to me goes without saying, but we've spoken about this on the show. I've seen hundreds and hundreds of matters where an employee has to go off on a medical leave or wants to come back from a medical leave or is not ready to come back, and the employer says, well, that's not our problem. We're going to let you go. You as an employer can never let someone go because of a medical condition, because of a disability leave, because they've been off for a while. As long as the employee has a doctor's note that gives legitimacy to their inability to work, you have to allow them that time off. if you don't, not only would that be a wrongful dismissal, you're going to owe them significant compensation, that can also be a human rights violation. So for employees out there, the only thing you really need to be off on a medical leave is a doctor's note. Speak to your doctor, whether it's COVID related or not. This doesn't have to be COVID related. If your doctor says you cannot work, that's all that matters. Your employer can't do anything. And if your employer tries, in most cases, that's going to be completely illegal.
Talking about things employers shouldn't do. Now, this next one here is really, I think, if you think back like 8 years, this is the reason why we got the radio show started in the first place. And that is, don't base severance just on the ESA Employment Standards Act or the Employment Standards Branch minimums. Don't do that.
You know, often, John, what small employers or even medium-sized employers do when they want to let someone go, they go to Google and they say, what do I have to pay someone if I let them go after 3 years? And oftentimes they're going to come across the Employment Standards Act that will provide a week's pay per year of service. They think, okay, I got a 3-year employee, I'm going to pay them 3 weeks. I just saw that online. Wrong, wrong, wrong. What that information on the Employment Standards Act is only a person's minimum entitlements. Their full legal entitlements are significantly greater than that. So that same 3-year employee who you think you only have to pay 3 weeks to may be owed 6 months, 7, 8 months pay, months, not weeks. So then you're going to face a wrongful dismissal claim. Understand that the Employment Standards Act only provides for a small portion of a person's termination entitlements. And that the flip side for employees, if you are let go, it's not a week's pay per year of service. Doesn't matter where you are, it's going to be significantly greater. So what can employers and employees do to find out what their rights and obligations are on termination? We talked about it before. pocketemploymentlawyer.ca. Again, it's pocketemploymentlawyer.ca. It's a tool that allows you to calculate how much severance is owed or how much you have to pay someone. It's easy. It takes seconds. It's anonymous. There's no excuse not to use it. And if an employer thinks it was a week's pay, they're going to find themselves on the wrong side of a wrongful dismissal claim, and by then it's too late to fix it.
Get to a couple more of these before we take a break here. Things that employers should never do. This one, we just finished doing a complete radio show on this one, is that don't treat an employee as an independent contractor when they are actually an employee.
Right, and this is certainly a mistake that employers make all the time, something they should avoid. If someone is really going to be an employee, they're going to come to work every day, they're going to come back the next day to do it, they're going to work exclusively for you, you're going to tell them what to do. They are employees. So you calling them a contractor or calling them a consultant doesn't make them so. You're either, in the eyes of the law, an employee or you're a contractor. And how you call yourself, what the company calls you, what you decide to call someone, none of that matters. The law is the only one that can determine what someone is. If you're hiring someone to do a project, to work a few hours here and there, they're going to really decide what to do, then that's a consultant. That's a contractor. You're hiring someone to actually work for you. You're going to be someone's boss. That person is an employee. And if you misclassify them, number one, you're going to potentially get into trouble with CRA. And number two, you're going to owe them significant amounts potentially down the road. Vacation pay, overtime, holiday pay, severance. And if you've been working supposedly as an independent contractor, you're not sure if you are, you're probably not. Check out pocketemploymentlawyer.ca. There's a tool there that allows you to find out if you're an employee or a contractor, but you probably have been misclassified.
We're talking about things that employers should never do. Last one on the list for this week is do not ever ignore workplace harassment.
Right, and I wanted to talk about that. I wanted to mention that because too many times I've seen situations where employers either ignore workplace harassment, they don't deal with it, or they just don't do a good enough job. Workplace harassment is a real thing, and every employee has the right to work in a harassment-free work environment. It's one of the most fundamental rights that we all have, and it's the employer's obligation to make that workplace safe and healthy and supportive. So as an employer, if you're aware of workplace harassment, if someone brings a complaint, or even if you just become aware by observation, you have to deal with it. You have to investigate, whether you do the investigation or you bring someone from the outside to investigate, and then you have to take measures to fix that problem. If you ignore it, that's a violation of a number of statutes. That could end up being a human rights violation. That could end up being a constructive dismissal. It's wrong, and it's going to cost you money. And if you're an employee, remember, you have the right to be harassment-free. Talk to your employer. Give them a chance to fix the problem. If they won't fix the problem, get in touch with me. Let me deal with it. But you shouldn't be suffering from harassment. That's inappropriate. The employer must do something about it.
And you know how to reach out about these or any other topics. First, you can go to pocketemploymentlawyer.ca. There's always the phone number, 1-855-821-5900, and employmentlawyer.ca. That's where we're going to go for our second phone call from our long-running radio show. Lior, that's coming up right now.
If you have been working for a company for more than 20 years and the company is selling out and this person has been told that she will not receive her package because they are selling to a different company, is that true that they can actually force her to go with the new company, therefore not giving her a package?
Mm-hmm.
It's a great question. And so let's be very clear. If your business that you work for, if the company you work for is sold, no, you cannot be forced, of course, to go work for the buyer. You cannot be forced. But if you don't go for the buyer, work for the buyer, depending on the reason, you either may get your full severance or only part of your severance. If you have a good reason as to why you don't want to work for the buyer, maybe they're relocating, maybe they're giving you worse hours or less pay, you have a good reason, then the company selling the business has to pay you your full severance, which can be as much as 2 years' pay. If you don't have a good reason, you say, you know what, I'll take this opportunity to go back to school, for example. You don't necessarily have a great reason. Well, you're still going to get your severance, but it's not going to be your full amount because you didn't accept the job. So severance either way has to be paid. Keep in mind, though, if you're going to accept the job and continue working with the buyer inherits your service, meaning if down the road they let you go, the severance that they pay you is going to have to account for the time you spent with the previous company as well. So if you're in a sale of a business situation, you're not sure what your rights are, hopefully I've explained things. If you're still unclear, reach out to me. Happy to talk.
Let's take a quick break here. Coming off of mat leave and no job to return to. We'll tackle that after a short break. To reach out to Lior anytime, the phone number 1-855-821-5900. Employment Law Show. Stick around.
You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You thought you had a secure job. You didn't see it coming. Now what do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back. Employment Law Show. John Scholes, Lior Samfiru, employmentlawyer.ca to reach out anytime online, or you can go to pocketemploymentlawyer.ca. Catch our radio show as well. It's been doing that for years and years. We get a ton of phone calls every week, and we like to play the calls back here. Lior, phone call number 3 for this show today is coming up right now.
I just want to know what the obligations are of an employer when somebody does return from maternity leave. So what if they're saying that they're a small company, there's financial strife in the company, and we can't afford to have that position anymore, we've eliminated it. So I'm just not sure what the recourse would be if the employer actually says, you know, no, we can't afford to take you back. Like, can they just say, you know, we're going to give you a severance, and what would the obligation of them be at that point?
So John, the obligations of the employer when someone is on a maternity leave is to take them back to work. It's as simple as that, to take them back to work at the same job, at the same pay. Not only that, if the pay for the job in the meantime has increased while they were off on a maternity leave, they have to give them the increased pay. The employer cannot decide that they don't want to bring you back. They cannot decide that they like your replacement better. They cannot change your job because you're on maternity leave. All these things would be a breach of the Employment Standards Act, would be potentially a human rights violation. It would be wrong and illegal. Now, the only exception is situations when there's legitimately no more job for you, not because you were on maternity leave, just by virtue of how things develop. If you would have been out of a job anyway, if you hadn't taken a maternity leave, okay. If the position has been eliminated, there's no one doing it, there's nothing to do at all with your maternity leave, That may be the exception where the company decides not to bring you back or is allowed not to bring you back. Keep in mind, I've seen many situations where a company says, no, trust us, we really don't have a job for you, where in fact that's not the case. So you have to be very, very careful. But if legitimately the company absolutely does not have a job, in that situation, they are allowed to terminate. Of course, they would have to pay full severance, all right? Potentially even more severance because of the fact that if you're just coming back from maternity leave, it may take you longer to find another job than it would otherwise. But yes, you can be let go with severance in that situation, but be very, very careful. Don't just take anyone's word for it. You have to be absolutely sure that there is no job. If there is a job for you, if someone else is doing it, they have to bring you back or it's illegal.
Again, you have questions anytime when we're not on the air or otherwise. Terminationquestions.com is a great resource for you. You can go there anytime. We'll get to one from Jill. Jill's up next. Lior says, I will likely be recalled to work in a few weeks. I've heard from co-workers already back at work that our boss isn't following any of the rules set by public health. Can I refuse to return to work? You're getting this more and more, eh?
I do. I've been getting this often. And the short answer is absolutely you can refuse if your employer is not following guidelines with respect to physical distancing and other guidelines established by government to ensure workplace is safe. You have a right to work in a safe work environment. So it's unacceptable for an employer to have you working without taking measures to protect you. That said, I would not take your coworker's word for it. Best advice is call your employer and ask the question. It's a legitimate question. What have you done to ensure that I'm safe? What have you done to ensure physical distancing at work? If your employer tells you, here's what I've done, then go to work. And if that's correct, you're fine. If it's not correct, if whatever your employer says is false, there's no physical distancing, no measures have been put into place, you absolutely have a right, and I would say an obligation, to refuse to work. You cannot be punished in any way, shape, or form. You can even potentially get the Ministry of Labor involved here to investigate and to make corrections. You should not go to work, especially now, not these days, unless your employer is following guidelines, but ask the question to your employer. If someone else says, no, they're not doing it, not good enough, you want to find out for yourself as best as possible.
Again, terminationquestions.com. I think we got time to slide one more in, pal. And this one's from Deborah. Says, a company I have been with for 2 years is forcing us to work overtime during the COVID-19 crisis without getting paid for it. If we refuse, we run the risk of being written up. Does the employer have the final say on this one?
Wow, no, not at all. It's illegal. If you work overtime, overtime has to be paid. That's true even if your employer is not asking you to work overtime. You just have to work it to get the job done. Your employer still has to pay you. So for the employer to demand you work, not pay you, and then threaten you if you make noise about it, it's illegal on so many levels and in so many respects. If you work overtime, your employer has to pay. Their refusal is illegal. Their refusal can also be considered, if you want it to be, as a constructive dismissal. You can file a claim for the Ministry of Labor for unpaid overtime. I can help you, but no, your employer cannot say, we need you to work, but we're not going to pay you for that. The most basic thing when it comes to workplace laws is I come into work, you pay me for my work. It's as simple as that. If the employer cannot pay, then it should not have employees working. That's very, very basic, and the law is very clear on that.
You know, we've got to get out of here in about a minute, but just before we go, just reiterate one more time that employment laws, as far as the common law, is still robust and up and running, right?
Absolutely. We've heard that various governments trying to make some changes to Employment Standards Act, etc. Remember, ultimately, it does not matter. Your rights are what the courts have said over 150 years are, what the rights are, and those have not changed. So whether it's constructive dismissal, temporary layoff, an employer inability to change terms of employment, those still apply. If you want to know your rights, call me. Go to pocketemploymentlawyer.ca. Employment laws are still here and still protect you.
We're done. You want to reach out, employmentlawyer.ca and 1-855-821-5900. Appreciate you sticking around. We'll catch you next time in the Employment Law Show.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.